and anonymize, or are we required to provide access and to make it identifiable so that we can do that? I think there's challenges there. And the last thing that I want to challenge you is to think about how interoperability works, not only among the regulators, and Malcolm's going to talk about that, but among the other participants in technology, in standards, in policy, and in ethics, because I think that will give us a much richer debate. Malcolm?
And thank you. I go last. The one thing that I would uniquely say sitting at this panel is, as a person who has hosted one of these conferences, that is the only way you can know how hard it is to do. The effort that has been put into running a conference like this by Mrs. Madhub and her team has been astounding, and I just want to add my thanks and praise for the beautiful, beautiful conference. And in fact, I want to return to the conference theme, the actual words of the conference theme, as she gave them to us at the beginning of the conference. A world order for data protection, our dream coming true. I love the way she used the word coming rather than come. And the theme that I want to draw out of what we heard over the last couple of days is the one about the cooperation between privacy regulators and what a multifaceted jewel that is. And I'm going to preface my remarks with this, that as a privacy regulator, the only thing that matters is whether you have made a positive improvement to the privacy of individuals, even if they haven't heard of you. We must come back to that. But of course, that must be done as a privacy regulator in a way that is ethical and effective and efficient. And each of those three aspects came up, and of course, lawful. But we also need, as privacy regulators, to be doing it in a way that encourages innovation, so that we can all benefit from the wonderful opportunities that are in front of us, whether it is mobile phone telephony data for controlling and understanding the Ebola virus, or safer highways, or all of the other things that we're talking about. We must remember that. But our host also reminded us of one other thing in her opening remarks, and that was this. She quoted Winston Churchill: "You will never reach your destination if you throw stones at every dog that barks." And I do wonder if sometimes we're doing that. And that led me to look at the history of recent conferences. In fact, we can find online at privacyconference2013.org the history of all of the conferences we've ever attended and the resolutions that have been adopted by the conferences since the start of the millennium. And I counted about 70 resolutions in that time, of which roughly 25 relate to organising ourselves one way or another. That's a very high ratio. We've been trying to do this for a very long time. It certainly reinforces our host's point. I also want to look at some of the facts of life of being a data protection regulator, and in particular some of the things that we heard about that in the conference here. First of all, an ever-increasing proportion of data is flowing across borders, and the management of that data involves more than one jurisdiction. There is so much more of this to happen. So when I was convener of the conference in 2003, you could see that this would happen, but nobody was really very interested in talking about it. Now it is happening, and we are talking about it. But wait, there is more to come. We heard of the other great challenges: surveillance, the cloud, big data and analytics, Internet of Things, and more. Another fact of life: data protection commissioners have very limited resources, some of them extraordinarily limited resources, and reducing against this incredibly complex, expanding environment. So in order to make the difference that we must make as data protection regulators, We have to think of the combination of the laws that as they ought to be and how we can give effect to them, enforcement, other forms of ensuring compliance with those limited resources. So against that context, I look at the steps we have already taken for collaboration leading up to today, whether it is GPEN, which in turn is a product of the OECD recommendation on cross-border cooperation in the enforcement of privacy laws, the Association of African Francophone Data Protection Authorities, about which we heard yesterday, the Ibero-American Data Protection Conference, the Asia-Pacific Privacy Authorities, or in my day we called them PANZA because we were so much smaller then, Privacy Agencies of New Zealand and Australia, the APEC Cross-Border Privacy Enforcement Arrangement, and so many more if we could list them. But there is in fact in this age one more group that we didn't mention at this conference, and that's us old fogies, the former regulators. There are, I think, 5 people in this conference today at least who have been regulators in the past, and there's probably a couple more. They are, one way or another, a fount of knowledge, wisdom, available resource, energy. They've got insight. They can be mentors. There's a number of ways in which been there, done that, can be incredibly helpful to the people who are just starting out or have something they really want to think about. And we are going to be joined in the alumni of former regulators by one of the most astounding of those regulators, Peter Hustings. I became Privacy Commissioner in 1999, and Peter was already a veteran as a regulator at that time. He's probably got more of the accumulated wisdom of the privacy regulators than anybody else on the planet. We owe him a great debt of gratitude. Thank you very much, Peter. By the way, Richard Thomas, one of the former regulators who is not here, has created a little database of all of the former regulators that we can find, so watch out. But there is so much more to do. And hence today, the Global Cross-Border Enforcement Cooperation Arrangement. This has the potential to be a huge step forward. It has wide eligibility criteria already as specified in the detailed document, including people who want to join that arrangement among the accredited members of this conference, the enforcement authorities who, from any government that has signed up to EU Convention 108, any member of GPEN, a participant in the APEC Cross-Border Privacy Enhancement Arrangement, a member of the European Union Article 29 Working Party. But I would have to say, if we want to collaborate, we need to think more widely, and at this conference we heard a lot about that. And in particular, think of those who are regulators who have a very significant impact on the privacy of the people on this planet who are not attending this conference as data protection regulators, who nevertheless take their privacy responsibilities very seriously. Some of them are telecommunications regulators, banking regulators. They may have a different interpretation, but they are often taking privacy very seriously. Then think of the various professions that are so important to us, and we heard earlier today from Mukesh Haikawal and the World Medical Association, the medical folk who have so much in their personal internal governance frameworks for how they handle the privacy and confidentiality of individuals' incredibly sensitive information. Think of the accounting profession. Just imagine when the accounting profession does, as it will do, declare that information has to be brought to the account on the balance sheet as an asset. Many large organisations will find that the largest asset on their balance sheet is information. The revolution that will cause to the management of the information asset will be profound. Security professionals, the International Association of Privacy Professionals, there's many more. And then think of the creators of other kinds of frameworks, and again we heard about this at the conference, but especially standards. And I think, as we heard about ISO 27018, which claims to be the first baby ISO born in the cloud, there is much more to come. There is a form of interoperability that may well work very well for us, and it provides the potential for forms of compliance and enforcement that does not involve those scarce resources of the privacy regulators. Yes, there are challenges, and we saw them in this conference. For example, the discussion on one-stop shop opened my eyes to some of the incredible complexities in Europe on dealing with some of these issues. The regulators' do's and musts for effective enforcement was another session where we heard about these issues and some quite creative interpretations of the law that people were using as data protection authorities to do what they should do. But now, I repeat, is the time to act. And so I go back to the words of Lao Tzu from 2,500 years ago. A journey of 1,000 miles begins with a single step. So many things are profound from long ago. So my vision is this: at the end of the 40th International Conference of Data Protection Commissioners and Privacy Commissioners in 2018, the newest commissioner, the one who has still not yet joined us, comes out at the end of the second day and says to one of the conference veterans, "I can see this all works in practice. I wonder if it works in theory." Because we have to practice. There is learning by doing. There is achievement. And if that happens, I believe that it'll then be a world order for data protection that will be a dream come true. Thank you very much, everybody, and over to you, Peggy.
Marie, let me give you the opportunity. Do you have any final 1-minute comment that you would like to make?
First, I see also the progress of IT industry. In the 70s, IBM supported national laws, and I hope to see that again with more and more IT enterprise. I was very happy to see that there is now a network of privacy engineer. If they want to work, if they need some work, I can tell them. What else? Yes, about interoperability. Sorry, dear. I would like to say that in legal terms, internationally, we should speak about different legal system which has the same effect at the end, because this is what we are looking for. Depends how we get there, but we get to the same place. For the others, we play with tools, practical tools. The first was the contract, then the BCR with IBM in 83, I think. Ian may tell me. And now this referential between EU and APEC. Of course, I would say, if I may say something, I would prefer to see a convention going on in Asia Pacific. That would be interesting. Because when you have an international document, you may have also a court, so it's an appeal for national level. So if the national level doesn't go well, you know that we are not in a completely safe, sustainable privacy world. We have to safeguard that. It can be useful. Same in Latin America. There is a court, an Inter-American Court for Human Rights. It could play a real game. I say game. No, you see what I mean. So that's what I would like to see in the future. Thank you.
Thank you. Thank you, Marie. Marty, can I let you have a last observation?
I'd actually like to talk about you can only do what you see and have a vision for. I think Malcolm is absolutely right that we need to take things and put them into practice. As I see huge changes in the world over the next 3 years, both in the world of technology and the world of policy, I think we have to have, like a race car driver who envisions every corner before he comes to it, I think we really have to have a solid vision of how we protect individuals in this age where technology evolves incredibly quickly.
Thank you, Marty. And I'm going to close by picking up on something